My name is Jenny Faber, and I'm the editor-in-chief of Career Education Review. I just want to first thank you all for joining us today for a webinar. The webinar's called Title IX and Sexual Violence in the College Setting, presented by Catherine Brody, Steve Chema of Richard and Layton, and then Tom Chema from the Gateway Group. Before we begin, I'm just going to tell you a little bit about Career Education Review. As you may know, we have an 88-year history of providing information to the career education community. We publish twice a month, and we strive to be the source of news, best practices, ideas, and commentary for the sector. In our upcoming issues of CER, we're really excited. We recently interviewed Daniel Greenstein from the Gates Foundation. He's the Director of Education Post-Secondary Success, and that will be in our November issue. We also had the chance to interview Harry Alford, who is the President and CEO of the National Black Chamber of Commerce, and that will be in an upcoming issue. Some of the themed issues that are coming up are going to be regarding strategic planning, campus administration, military and veteran affairs, and workforce development. And then we will have another webinar with Richard and Layton, and the next webinar will be the Department of Education's Gainful Employment Final Rule, and that will be taking place December 11th at 2 p.m. Eastern Time. I will go ahead and send more information on that after this webinar. To answer a few questions before we start, I will be recording the webinar and it will be available on the Career Education Review website along with the PDF. You'll receive an email either tomorrow or Monday with that information. If you have any technical issues during the webinar, please go ahead and send me a message through the chat function, and I'll try to help you with that issue. Also, we'll be saving 10 to 15 minutes at the end for questions, and you can go ahead and submit your questions with the question feature, and I'll read those off at the end as much as we have a chance to. I want to thank Peter and his team for their continued support of Career Education Review, and I'll now go ahead and hand it over to Catherine Brody.
Great. Thank you very much, Jenny, and thank you for all of you that are participating on this webinar about an important topic. And we have a lot to cover, certainly. We have 77 slides. We're not going to go through each of them in detail, but really our overall goal today is to allow you to refamiliarize yourself with the Title IX requirements as they apply to sexual violence. There are some new developments in the law over the past few years, and we are very lucky to be joined today by Tom Chema, who has been part of a group of higher education officials that has been actively participating in the White House task force to protect students from sexual assault, so is very familiar with the policy developments from the administration standpoint, and he's also one of 16 higher education leaders that serves on the Senate's task force on federal regulation of higher education, looking to streamline regulation in the higher education space, which we are all in favor of. So let's start right now with Title IX and what it is. It's been in the law since 1972. Most of you already have your required statements of compliance with Title IX in your policies and handbooks and other documents. This Title IX is generally most well known for equity in athletics, but the current administration has really been pushing the envelope, pushing the boundaries of what Title IX means for protection of students with respect to sexual violence occurring on campus. And so Title IX is the statutory authority for those current initiatives. We also want to talk about the relationship quickly between Title IX, Title IV, and the Clery Act, and we'll be touching upon this throughout the presentation. But it can be somewhat confusing with respect to Title IX and Clery Act overlap. But to set forth the basic structure, all educational institutions that receive any federal funding are subject to Title IX and its protections against sexual discrimination in the educational setting. Title IV institutions are subject to Title IX pursuant to the condition of their program participation agreement. And if you look at your PPA, you will see that it says that you will comply with Title IX. All institutions separately must comply with the Clery Act. And this, as you all know, is a separate statute that governs campus safety, and only Title IV institutions are subject to the Clery Act. Now, Title IV institutions are subject to both Title IX and the Clery Act, and both statutes address sexual violence on institution of higher education campuses. But they're separately enforced through separate offices. So ED's Office for Civil Rights handles Title IX enforcement, but ED's Office of Student Financial Assistance handles Clery Act enforcement. So what you'll see is some overlap and some inconsistencies with respect to definitions and policies required under each statute, and we'll talk a little bit about that. But why we're talking about this today, in the light of the fact that Title IX has been around for a while, is the renewed interest in this statute as it applies to sexual violence in the college setting. So sexual violence and its impact on students attending institutions of higher education has been a very renewed focus of the current administration, and the topic has received extensive media coverage. In January 2014, the President signed a presidential memorandum establishing a White House task force to protect students from sexual assault, and created a website for schools, students, and the public to disseminate information about best practices. And the Office of Civil Rights has also made increasingly more public and transparent its settlements with institutions of higher education regarding Title IX violations. And I think latest information is there are 89 institutions of higher education currently undergoing a Title IX investigation specifically on sexual violence. But at this point, I want to stop and allow Mr. Chema, Tom Chema, to explain his role in the task force and his participation on the task force, and the reason why institutions of higher education should be paying attention to this particular issue.
Thank you, Catherine. I was fortunate to be part of a group that the American Council on Education put together to assist the task force, which was, as you know, headed by Vice President Biden and was basically cabinet officers. Our group of college presidents and general counsel of colleges were put together to try to give them some insight from the college's point of view, because it became very evident early on in this process that the White House was focused on enforcement actions and took the basic view that if we dealt with individual incidents of sexual misconduct on college campuses appropriately, that would be a deterrent to those actions going forward. Many of us have questions about whether that, in fact, is going to be a strategy that is going to be successful, and think that perhaps we should be focusing in some other directions. Nevertheless, it is clear that this issue for President Obama and his Department of Education is going to continue to be getting a lot of attention. The task force issued a report, and it was important, I think, for us to note that it was called the initial report of the task force. It anticipates that there will be continuing work by this group and other reports and other regulatory actions that is going to come beyond it. I don't think this is something that we should think about as going to go away when this president's term is over. In fact, the antecedents for this were in President Bush's Department of Education under Secretary Spellings. So this focus on sexual misconduct, they refer to it as sexual violence, but I think really it would be better referred to as sexual misconduct, is bipartisan. It's not going to go away. It is something that the federal government has become invested in now over the course of two different parties' occupancy of the White House and control of the Department of Education. So I think we all have to be mindful of this. In the past, Title IX was generally looked at as something that affected mostly athletic programs. But in fact, the Title IX applies to every institution of higher education that receives any federal assistance. And I think that because of the potential for risk to our institutions, primarily reputational risk, but also financial, it is something that behooves us to pay very close attention to and to focus on. And you all who are on this webinar are to be commended for your interest in the subject and trying to ensure that your institutions are doing the right thing. Back to you, Catherine.
Great, thank you very much. Next slide. Can I get the next slide, slide 5?
Okay, I'm sorry, Catherine.
No problem.
Catherine, are you able to see the slide now?
Nope.
Okay.
It is up, I see it.
Catherine, this is Jenny. The slide is up, so if you just want to go ahead and talk.
Okay. All right, no problem. I have my other copy here. Okay, so basically what I want to do is just look at the Title IX's link to sexual violence and just make it a little bit more explicit for folks. So looking at the definition of sexual violence and its tie to Title IX, sexual violence is the physical sexual act perpetrated against a person's will where a person is incapable of giving consent for a variety of reasons. And those acts are considered forms of sex discrimination prohibited by Title IX, and that's the tie-in with Title IX. With respect to the general framework for institutions' obligations to protect students under Title IX, this slide 6 provides the language from the April 2014 Department of Education Q&A, and we'll be delving into this particular aspect in more detail in this webinar. But sexual violence can be carried out by an employee of the institution, other students, or third parties. But in each case, students are protected by Title IX when the alleged conduct is sufficiently serious to limit or deny a student's ability to participate in or benefit from the educational program. In other words, the student signed up for the educational program for the benefit of the education, and the sexual violence is such that they are being stymied in their ability to benefit to some degree from the benefit of the education. So Title IX protects all students against sexual violence as well as sexual harassment in all forms, and institutions must take prompt and effective steps to reasonably calculated to end the sexual violence, eliminate the hostile environment, prevent its reoccurrence, and as appropriate remedy its effects. And we'll get into these particular requirements in greater detail further on in the presentation.
If I could interject, that
Sure.
issue of trying to ensure the appropriate environment on campus really is the key to this. And if you look at many of the enforcement actions that have been taken by the Office of Civil Rights, you will see that that permeates the underlying issue from the OCR's point of view. What was the environment like for those students? So this affects every campus and every educational institution. It doesn't really matter whether you are a traditional state four-year institution or a private or a proprietary institution. The question is, what is the environment like in your educational institution, and how are you ensuring that the sexual misconduct does not create such an environment that is hostile to that learning environment that we're trying to provide to all of our students.
Tom, and good afternoon, everybody, and good morning, everyone who might be on the West Coast. This is Steve Chema. I wanted to also just amplify on what Tom just said. In our experience dealing with OCR, they are, very much aware that this is a very broad social problem, and that this is occurring all on campuses all over the country. And so the fact that an event occurs on a campus, doesn't, I think you can anticipate them thinking that it doesn't often mean that that institution is bad because this happens. And so they're not necessarily most concerned that these problems occur because they understand, the magnitude of the social problem that we have. What they are interested in is how is the institution handling it? What do they learn, and what can they do to prevent it in the future? And I think if you look at OCR's reading room online, you'll see these enforcement actions that they've intentionally made public. And you'll go through that list. You'll see it reads like a who's who of higher education in the United States. These are all good schools, but they all have problems because this is a social problem. And I guess that will dovetail fairly well into our next slide, which is, Catherine had mentioned that there is a significant amount of overlap between an institution's responsibilities under the Jean Clery Disclosure of Campus Security Policy and Campus Crime Statistics Act, the Clery Act, and what Title IX requires. And we specifically wanted to highlight a few things in this presentation that arise out of the 2013 Reauthorization of the Violence Against Women's Act, which amended Clery in a few important ways. We've got a few slides in the next minute or so that I'm going to go over, but I also want to direct you, in case we don't have a lot of time towards the end of the day, to slides 63 through 70, which contain a little bit more detail. But as you probably are all aware, we had just this past month a final rule published implementing the statutory changes and interpretations of those changes that came about through the 2013 VAWA Reauthorization and Campus Save Act. And those were, I think, probably described as enhancements to Clery. They didn't necessarily change the fundamental focus of the act, which is to create a duty for institutions to report crime that occurs on campus and crime statistics, to issue timely warnings, as well as emergency notifications when there is events that could cause imminent harm on campus. The requirement that the institution have a collection that is published of their various policies statements, that they have a reporting procedure for transmitting this information, all that information contained in an annual security report to the department. And of course, there are some teeth. The department's Office of Federal Student Aid, anybody who's had a program review over the last year or two is probably well aware that this has been an area of emphasis, and that actions arising out of Clery Act violations can now be can result in a fine of $35,000 per offense. And there's also this nuclear option, which we note, to our knowledge, has never actually been invoked, but you could, in theory, wind up with the loss of or the revocation of your program participation agreement. What changed is a number of things, but one I wanted to highlight on this slide is the second bullet point, that there always has been a requirement to disclose crime statistics and crime prevention programs and policies. It's just now that annual security report now contains 14 different policy statements. And I won't go through all 14, but they range over a number of subjects, some of which are directly also covered by Title IX and others not. I mean, you've got reporting offenses that have occurred on campus. Those might be Title IX sexual misconduct or sexual violence offenses. They might not be. You've got to have a policy that discusses the security and access to your campus facilities. You need to have a crime prevention policy, a policy that discusses the possession, sale, and use of alcoholic beverages, procedures that will apply to victims of domestic violence, victims of dating violence, victims of stalking, and victims of sexual assault, all of which are defined now in these regulations. And those definitions become important because these are offenses which, if they're occurring on campus, are probably also events which could trigger your Title IX investigation responsibilities. Again, this is sort of a summary slide, and I would refer you to slide 63 to 70 for greater detail about the definitions. But I did want to kind of skip ahead to one, which I think probably shows what a challenge that these new definitions can present to an institution. And what you're seeing here is the definition of dating violence, which is violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. which, I think in the abstract is probably a reasonable definition of what dating violence is, except that I don't think that any of your students are ever going to report to a responsible officer that, he or she, has been in a social relationship of a romantic or intimate nature with the victim. I think what they're probably going to be describing is, in their own words, something that it might be very difficult to tell if it qualifies. They might say, I'd seen this person once or twice, or we were hanging out. They'll use, cultural or colloquial phrases, and it's going to be, the institution's responsibility to try to decide whether those descriptions really fit this definition. And I have to believe that that's going to be a very difficult challenge going forward, and it's going to require a very precise level of training and very good listening. What the Office of Civil Rights Guidance says that maybe is useful for us at this point is they recognize that this is going to be a tough call, and their suggestion is that institutions should err on the side of assuming that the victim, in their words, the perpetrator, as we talk today, I'm going to try to use the word respondent, which I think is a little less charged, but the victim and the perpetrator, were in a dating, relationship. So if it's a close call, they want you to err on the side of determining that type of relationship exists because, they don't want you to run the risk of underreporting. Similarly, I think there are interpretive dilemmas posed by the definition of stalking too. Stalking, as defined in the Clery Act now, means engaging in a course of conduct, and a course of conduct can be a wide range of words, behaviors, and means that is directed at a specific person that would cause a reasonable person to either fear for his or her safety or the safety of others, or to suffer substantial emotional distress. And substantial emotional distress is defined as a significant mental suffering or anguish that may, but does not necessarily require medical or professional treatment or counseling. So that's a lot to try to digest. Obviously, I think this is going to be always a fact-specific inquiry, and in most cases, I think you'll know stalking when you see it. But I just raised this now to highlight the fact that discharging these responsibilities, whether it's collecting information and making your required reports and disclosures, or acting on what your knowledge is in the Title IX context, is going to require you to really listen to your students, to really conduct pretty thorough factual inquiries, and to make some tough decisions. Finally, the purpose of this slide is just to underscore that while there are substantial areas of overlap between what Clery requires you to do and what Title IX requires you to do, oftentimes Clery and the guidance for Clery might seem as though you have more flexibility than what Title IX will say you must do in the same situation. And the point is that the Clery Act and the VAWA Reauthorization did not supersede any of OCR's guidance or any aspects of Title IX. You're not to try to read those two provisions and those two requirements side by side and find that there's a conflict. What you need to do is try to find a way to harmonize them, because you have to comply with both. Some examples of what I'm talking about might be that under the Clery Act, you're required to have policy statements that would describe what your hearing or disciplinary procedures would be with respect to sexual violence or offenses of sexual violence, and you're supposed to say what your standard of proof is, but it doesn't tell you that you have to have a particular standard of proof. Title IX, however, is much more specific. It says that your investigations into sexual violence need to apply a preponderance of the evidence standard. So you couldn't read those two things to say, well, Clery says I've got more flexibility, I can impose whichever standard I want. That's the fundamental idea. And now I'm going to turn it back to Catherine.
Great. Great. So now we're going to talk about when the institution is deemed to have notice of an alleged incident of sexual violence. And under the guidance, basically an institution of higher education is on notice of sexual violence if a responsible employee, and we'll talk about that in a few minutes about who a responsible employee is, knew or in the exercise of reasonable care should have known about the incident. So this is an imputed knowledge to the responsible employee, even if they did not actually know but should have known about the incident. And this arises in situations, for example, like a social media situation where an incident blows up on social media between students that points to the probability of sexual violence, and that information trickles back to a responsible employee. If they find out about the potential for such an incident through social media, they're on notice of the importance of conducting an inquiry to determine if, in fact, they need to initiate their investigative procedures. I should note that this standard is different with regard to litigation. Title IX has a private right of action in it, where institutions are liable for actual knowledge of sexual violence that is not responded to. In an administrative enforcement context, it's the lower standard of knew or it reasonably should have known about the incident. So when an institution is on notice of the incident, that triggers the institution's requirement to begin an inquiry to take prompt and effective correction action for any incident involving sexual violence. The next slide talks about the school's obligation to respond. The institution must take immediate and appropriate steps to investigate and otherwise determine what has occurred. If the investigation concludes that the sexual violence created a hostile environment, then the institution must then take prompt and effective steps to reasonably calculated to end the sexual violence, eliminate the hostile environment, prevent its reoccurrence, and as appropriate remedy its effects. The institution must protect the complainant, including taking interim steps, and we'll talk a little bit more about what those are potentially, while the investigation is pending. In other words, you can't leave that complainant in a situation that continues the harm to that complainant while the investigation is pending. Now, there are some basic Title IX procedural requirements that we want to touch upon. One is dissemination of a notice of non-discrimination. This is a basic statement by the institution that it does not condone sexual discrimination or discrimination under Title IX. A lot of you already have that in your policies and catalogs. It's been out there for quite a while. The second is the actual designation of a Title IX coordinator, and we think this is less prevailing with respect to where institutions are right now. You do need to designate a Title IX coordinator under Title IX, and you must adopt and publish grievance procedures that provide for the prompt and equitable resolution of student complaints. So these three requirements apply to all forms of sexual discrimination, not just sexual violence, but are very important with the administration's efforts to prevent and effectively respond to sexual violence. And we'll talk a little bit more, too, about what the VAWA amendments added to these particular requirements in terms of grievance procedures.
Catherine, if I could jump in, this is Tom Chama speaking. In the early days of my tenure as president of Hiram College, we would have thought that providing that notice was appropriately done by having the language of our policy in our student handbook, which every student gets when they come in the door. And that might have been effective 10 years ago, but today that is not going to fill the bill. It's really going to be important for that statement and the policies of the institution to be published and republished frequently. In the handbook, of course, but also every term when new students are coming in, this needs to be republished. It needs to be republished not only to the students, but to faculty and staff as well. And I think that great care needs to be taken in order to show the good faith that the institution is operating on, that you not only have the policy, but you're trying to get into the brains and emotions of all of the people involved, that you have the policy, what it is, what the impact of violations are going to be.
Okay, can you pull up the next slide, slide 18? Okay, these next couple of slides talk about the designation of a Title IX coordinator and the coordinator's role, and basically the obligations that the Title IX coordinator has to oversee Title IX issues at the campus level. But I'd like to have Tom just weigh in on his experience with regard to what types of individuals best serve as the Title IX coordinator and who should not be in that role.
Thanks, Catherine. I think I'll start with the who should not be. Definitely the CEO of the institution should not be the Title IX coordinator. That's a huge mistake and limits the flexibility that the institution has. It should not also be someone in the general counsel's office. If you have a legal staff, there will probably be conflicts of interest there. It should not be the person who is going to supervise any enforcement proceeding. If you have a policy that provides for a judicial panel, the people who are on that panel should not be the Title IX coordinator. If you have an athletic department, definitely don't make your athletic director the Title IX coordinator. You need someone on the affirmative side who is very organized, someone who is empathetic with students and with this issue, not somebody who has certainly a knee-jerk reaction that this is all overstated. It would be good to have that person be in the student affairs office, but again, not in the disciplinary chain, and a person who certainly has the ability to understand the complexity of this issue. As you can see, what we're going through here, it needs to, that officer needs to be somebody who can sort through, understand all of these nuances that we are talking about. It is not an easy job by any stretch, and it is not your grandmother's Title IX officer. This is something very different in what we need to make sure that our institutions are protected and that we are doing the right thing by all of our students, both a person who is a victim and also the person who is accused of a sexual misconduct activity.
Great, thank you. Well, we can go to slide 20 and have Steve touch upon the grievance procedure requirements under Title IX.
Okay, thanks, Catherine. What you're seeing here in this slide, and it's going to continue on into the next one, is elements that OCR put into the April 2014 Q&A guidance that essentially says, this is what we're looking for when we review your grievance procedures. And I think, as an exercise, it's really good to put this side by side against what you have published. But I want to go through some of these points really quickly, but to just show, I think thematically, beyond just the grievance procedures, this is OCR telling you what they think is important about compliance with Title IX and sexual violence generally. First, notice to the students and employees of the procedures, including where complaints can be filed. Clearly, they don't think that, and speaking to Tom's earlier point, that if you have a policy and a structure to take complaints and to handle them, but if no one knows what it is, it's of no use. And you will be criticized every time that a student is interviewed by an OCR attorney or investigator and tells them, well, I didn't know who to go to, which brings in point B, that that you have to be telling the community, both your students, also your employees, and other third parties that are on your campus or interacting with you, that these procedures govern complaints that can be filed by students or filed by others on a student's behalf, specifically dealing with sexual violence. And if it's violence that can be peer-to-peer, that can be employee on student, faculty on student, or third parties who have a reason to be on campus, or even ones that aren't invited and don't have a reason. So it needs to be global and holistic. Item C talks about that your procedures need to key in on these 3 or 4 hallmarks. They need to be adequate, reliable, and your investigations need to be impartial. And this concept gets repeated over and over, I think, in this presentation as we go forward, that the OCR expects that you're going to deal with both parties to a complaint with parity. In other words, if you're providing an opportunity for the complainant to present witnesses and evidence, or to be represented by counsel, or to have an advisor present, well, then you need to be able to offer that same level of due process, to the other party, to the respondent. Moving on to the next slide. Another key concept that we're going to see is that in your grievance procedures need to provide a way that you can undertake an investigation and offer things like interim relief in a reasonably prompt time frame. In other words, your reaction, needs to be, timely. It needs to be swift. There just isn't any room in Title IX compliance today for undue delay. Similarly, point E, written notice to the complainant and alleged perpetrator about the outcome of the complaint. This gets back to parity, but it also is a potentially protective item for you if there's an investigation into what you did after the fact. You're creating a record. So when you're providing this written notice to either party, you should also be retaining some in your own institutional records. And finally, point F, which I think we've already talked about a little bit already, but the real focus, I think, in the best way for an institution to have a positive experience when these events occur is to take effective steps to prevent reoccurrence of any sexual violence and to remedy discriminatory effects on the complainant and others. Like I said before, they're not going to say you're a bad school because this happened. They're going to judge you based on how you respond. The grievance procedures have to have a number of statements, in them, and that's what this list basically is relating. It's that the school has the right to investigate incidents of sexual violence no matter where they occur. It's going to define concepts like sexual harassment or sexual violence in a way that the community who's receiving these procedures can understand that when they would apply and when they wouldn't. It's going to provide some understanding for what the reporting protocols are. So, who can I go to relate a complaint, and will I be treated, with confidentiality? It's going to identify those persons so that those complaints can be made, and very importantly, it's going to articulate to the community that the institution will not tolerate retaliation. And it's interesting, we'll get to retaliation more in the future, but I do want to point out that means that the institution itself can't take any adverse action against anyone who participates in a investigation of sexual violence or lodges a complaint. But it also needs to take action to make sure that parties don't retaliate against each other. So the retaliation really has two meanings. Continuing, the notice of a student's right to file a criminal complaint and a Title IX complaint simultaneously. Oftentimes, what is the subject of a Title IX investigation could also be a criminal offense. We see this because of the Clery Act definitions. So it's important that students be advised as you're talking to them as the institution that they have a right to seek redress through a criminal complaint as well. And certainly you need to make sure that your investigation can coexist with that criminal complaint. And also you have a burden to try to make sure that if a student elects, or an employee or anyone who is lodging a complaint elects to do both at the same time, that you need to try to manage your investigation along with the criminal investigation in a way that it doesn't unduly burden the student. And a lot of times we may be talking about situations in which relating these events are traumatic. So it's important to keep in mind that there's going to be a good deal of coordination necessary. You need to be able to provide interim measures that can be taken to protect a student in an educational setting. Clearly, when you've got an event of sexual misconduct that is violence, the very obvious interim measure is making sure that you can provide a safe space for the student who's the complainant, that they don't have to be in the same classroom, for instance. Your grievance procedures have to state, as I said before, that the standard of review in the investigation is a preponderance of the evidence, and that means essentially that in determining the outcome, you're going to assess whether it's more likely or not that an act of sexual violence occurred in order to resolve the complaint. You need to provide a notice of potential remedies to the student, and students is plural because it's not just the complainant, but it may be to other students who are affected. Remedies, could be counseling and making that available. Additionally, and this is, I think, speaks to the deterrent point, perhaps that Tom mentioned early in the presentation, that we're talking about what are the potential sanctions that a perpetrator or respondent who's found responsible for an act of sexual violence would be subject to. And finally, again, making sure that the school's resources for counseling and advocacy and support are known to the community and to anyone who might be affected.
Steve, if I could interrupt,
sure.
One bit of advice that I would offer is, if you have not done so over the last, say, year, review those grievance policies right now and make sure that they are in concert with the law as it has evolved, especially over this past year. One of the things that I did again at Hiram was I had on my board a general counsel of a Fortune 500 company whom I asked to take a separate look at our processes and procedures and focus particularly on the sexual violence to help us decide whether what we were doing for the run-of-the-mill issue that comes up between students also worked in the context of this much more heightened, much more intense area of sexual violence. And I think that was a really good practice. You might want to have somebody from outside take a look at that process. The key, again, is going back to earlier comments, you're trying to have in your institution an environment where learning can take place. And that ought to be the basis of the complaint and grievance process as well. It's not so much about the institution punishing or being vindictive. It is what is in the interest of all of the parties involved in this situation. And as Stephen has said a couple of times, the issue here really is the reputational risk that you run by how you handle the situation. It's all about after the fact, not that, in fact, an issue occurred on your campus.
And I think that it's very easy to be daunted or to feel daunted at this point when you think about going through the process that Tom's describing and assessing your procedures. And to that end, I did want to bring up that OCR does seem to recognize that there really aren't any one-size-fits-all solutions out there, and that your grievance procedures need to be appropriate for your institution, your student body, your campus community, and they specifically, say that, you should be taking into account, differences in ages of your students. Tom was president of a traditional four-year liberal arts institution that, had a pretty large section of its population as, recent high school graduates who were first-time students. Certainly not, that wasn't all of them, but I think that was a good amount. Schools that don't have that kind of demographic, may have a reason to provide for different types of relief, different types of procedures. Similarly, your school size and administrative structures are another factor that makes a difference here that OCR recommends. I mean, they acknowledge the fact that you may not have the resources to have the same level of staffing that Ohio State University does, or University of Southern California. You may be a relatively small institution. and I think, you know, there you just need to heed Tom's earlier advice. Don't make the CEO or president the Title IX coordinator. Have someone, you know, who's responsible, but you can you know, acknowledge your own, you know, budgetary limitations and still, I think, come up with, you know, adequate staffing and adequate procedures. And finally, I think maybe the most important thing that OCR says in their guidance about this is that the institution should draw on what it's learned from past experiences. And I would relate this somewhat to the accreditation process, where you're constantly, you know, going through cycles of self-evaluation and data, you know, gathering and processing and trying to decide, well, how do we make it better? I think what Tom was describing that happened at Hiram, where, you know, they went out into their own community and had, you know, a third-party review, and they all, you know, took that input back and discussed it. I think that's something that OCR expects you to do, and, you know, anything that you have taken from, you know, the process prior that can inform a better practice or a change, I think would be looked favorably upon by OCR. So this will take us to...
Now we're going to move to slides 25 through 32 have to do with the issue of responsible employees and confidentiality. So I'm going to summarize some key points in these slides. They're very detailed and comprehensive with respect to the department's guidance. But responsible employees are basically those folks at the campus level at the institution that have an obligation to convey any information that they receive about Title IX violations to the Title IX coordinator. And from a school perspective, it's important that you carefully consider who to make a responsible employee, and looking at it from the standpoint of the student and who the student would view as an individual that they would approach with a problem related to sexual discrimination or sexual violence. Those individuals should be the responsible employees that are conveying that information to the Title IX coordinator. And the responsible employees, once they're designated by the institution, they need to know what their obligations are and be trained as to what their obligations are to record the information that's come into their possession and to report that information to the Title IX coordinator. And the students need to be aware of who those individuals are, because they need to know that that individual has an obligation to report basic information to the Title IX coordinator. So at a small school, it may be appropriate for you to designate teachers as responsible employees, responsible employees for purposes of Title IX if you think that is the person that the student is most likely to go to with, expecting that person to be able to take action to convey that information to the appropriate authorities at the institution. The responsible employees also have an obligation to make sure that the student who comes to them knows that they can keep the information, that the school can keep the information confidential to the extent that the law permits. So basically, with respect to confidentiality, it's a somewhat opaque topic right now. There's a lot of different guidance on this, but the basic obligation of the school is to try to respect a student's request for confidentiality, but there is a public safety concern that would override the interest of the student in maintaining confidentiality. So the Title IX coordinator or another individual at the institution is obligated to weigh the student's confidentiality request in light of other factors that the Title IX information that the Title IX coordinator may have. And an example is if student A comes to a responsible employee and that information gets to the Title IX coordinator that there was an alleged sexual violence incident on campus, but that student A wants to keep it confidential, and that information is not made public to the institution, the students at the institution, and then student B comes along and makes allegations with respect to the same alleged perpetrator, the Title IX coordinator, and that student B also requests confidentiality. The Title IX coordinator needs to weigh that. You've now got a repeat offender. There may be a need to override that confidentiality request and make it known that these incidents have occurred. But still, the school has an obligation to try to maintain as much confidentiality as possible, while also respecting their obligation to protect public safety and the campus safety. So that's basically a summary of that set of slides, because we're running short on time here. So Steve, if you want to pick up at slide 33.
Sure, and I think all I need to tell you about FERPA really is that, you know, there are two longstanding exceptions that allow you to do what Title IX tells you to do: release to the victim of any outcome involving an alleged crime of violence, well, we had a slide earlier that said you needed to provide written notice. This will not cause you to violate FERPA. Similarly, there's an exception that's been in the regulations for some time that permits institutions to disclose the final results of any disciplinary hearing against an alleged perpetrator of a crime of violence where the student was found in violation of the institution's policy on that offense. And clearly, there's information in there that could be student records, certainly would be otherwise subject to FERPA. That's why these exceptions exist. But because they exist, it does expose, I think, victims in some cases to the possibility of having their identities known to the complainant, the respondent, or the perpetrator, if you will, which I think you have to balance that against how strong are your anti-retaliation procedures and how good are your interim measures and remedies, because that if you can't protect the identity of the student, in most cases, I don't think you really would be able to. You have to make sure that you're not chilling the ability of victims to report these offenses. Which brings us to investigations and hearings. I want to sort of flip the order of these two bullets. First, the definition of investigation that's used for the purposes of sexual violence in Title IX is kind of interesting. It is, what you might normally expect, that there's a fact-finding investigation and a decision-making process to determine, what happened. But on the tail end of this is, outside of that quasi-judicial role, the thing that, as Tom said, is not really the point of emphasis, is the other part, that you eliminate the hostile environment, that you prevent its reoccurrence, and that might involve imposing sanctions or penalties on a perpetrator, but there are a broader range of remedies you need to have that can also accomplish that goal. That is part, and that is the role of the investigation. It's not just to determine responsibility. Specifically, or in addition, I should say that the OCR's guidance, again, attempts to allow you to right-size this. They know that how one institution will conduct an investigation of an allegation could very much be dependent on the demographics of that student community, the size and administrative structure of the school, applicable local legal requirements. So you need to be able to right-size this for you. And again, they direct you to learn from your past experiences. One thing that I've noticed is that in investigations and hearings, some institutions, choose to split the role, or maybe not split the role, but they choose to establish a position of, Title IX investigator. And I think this is done because they generally don't want the Title IX coordinator to have necessarily this prosecutorial role because of all of the other things a Title IX coordinator needs to do. But clearly not every institution has resources to have a specialized person in that role, and I think it's important to consider what is how do you want the Title IX coordinator to participate in an investigation. At the basic level, the Title IX coordinator needs to make sure that you're complying, that the investigation itself complies with that, it's adequate, reliable, impartial, prompt, and includes this concept of parity. But does that mean that the Title IX coordinator is doing the investigation? Tom, I don't know if how you arrange things at your school, but was this something that you had discussions about in terms of who takes the lead role when the school is gathering facts?
Yes, in fact, we did separate those functions. The Title IX coordinator was not in the role of prosecutor, but we left that to the standard process that we had for dealing with any issue that came up among students or between students and faculty, and that separation seemed to work pretty well. I think the key here is to understand that the college is not in the role of prosecuting a student. Again, we're trying to enforce our policies and procedures and ensure that there is an environment on the campus where all the students, including a person who may have been a victim of some sexual exploitation of one sort or another, has the opportunity to resume the role of being a pure, true student. One key, and I know we're starting to run low on time, but we may or may not get to it in great detail, but here I think it's incumbent on us to be proactive and interventional in what we're doing. And the intervention takes multiple forms. We've got to be educators on this subject as well as the substantive work of education we do. We need over and over again to be educating our students, our faculty, and our staff about this issue. And we need to cause the campus environment to change if necessary so that students also intervene when circumstances are likely to put a fellow student in jeopardy. And this often takes place in the environment of, say, a fraternity or a sorority, but also sometimes in residence halls, but other times in the local bar, because we know that, frankly, 95% of all of these incidents involve alcohol. So we need to have our entire campus communities more willing to intervene and try to undermine the circumstances that lead to these unfortunate incidents among students.
And I think, in the interest of time, I just want to make one more point, and then we can move on from investigations and hearings. It's the idea that you may have procedures that are, for code of conduct or student discipline. Those may be adequate for Title IX investigative purposes. They may not be. As long as you can determine that they're adequate, reliable, impartial, and can be concluded in a prompt manner, you're on the right track. The other piece of the puzzle is, you can't just end at whatever the disciplinary decision is. You have to, offer those broader remedies, and that's an area I think where disciplinary policies often don't go far enough. So with that, Catherine, did you want to discuss the criminal proceedings?
Yeah, there's a couple of points I want to make here. The most important of which is the fact that an incident is subject to a criminal proceeding does not relieve the institution of its obligation to investigate. Title IX investigations, where there's a basis to proceed with an investigation, are not discretionary. The criminal proceedings are on a separate track with a separate standard of evidence. So it's important that institutions understand that. Institutional proceedings can be delayed temporarily while the law enforcement needs to do fact-finding, et cetera, but then needs to resume again very promptly after that fact-finding is done. So just want to make clear that the criminal proceeding has no impact on the institution's obligation under Title IX to do its own independent investigation.
Yeah, and I know that the guidance that OCR has suggests that they think, in their experience, that 7 to 10 days is about what a typical criminal investigation. That's the amount of time a fact-finding, evidence-gathering stage, that's beginning to end. So, to give you a sense of how long, how much time you might really have to hold your investigation in advance, it's not much. From their
right. And with regard to off-campus conduct, the important point here is the institution needs to determine where it has notice of potential sexual violence incidents off campus, whether that conduct occurred in the context of an educational program it offers or an activity that it's sponsored and has a potential for continuing effects for students on the campus or in that on-campus program or activity. But it doesn't stop there. The department has also indicated that even outside of educational programs and activities, there can be off-campus conduct involving students that has the potential for creating a hostile environment on campus for a variety of reasons. So it's important for the institution to take a look at exactly what happened, who was involved, where it occurred, and is there a need for the institution to make an inquiry into the circumstances to determine whether there's some continuing a negative impact on students on the campus. So it's important to not just assume that off-campus conduct does not fall within Title IX obligations. Interim measures are a requirement under Title IX that the institution, once it has notice of a potential Title IX violation or incident, to take steps to ensure that the complainant is protected in their ability to continue to get the benefit of their educational program. And that may require taking interim measures. So the institution needs to promptly provide the complainant with options, basically, to allow that person to continue to receive the benefit of the education. That may include moving the complainant or the respondent to a different housing location, to creating a temporary restraining order, or no contact order rather, between two individuals, and to provide the complainant with updates on the status of the investigation so they're not left hanging with regard to what the institution is doing. So these are fairly common sense measures to make sure that harm is not continuing as much as possible for the complainant with regard to the allegations. I think we can move beyond this slide and start with slide 48.
Remedies are another crucial component here, and they're distinguished from the interim measures in that it might be the same kind of service that you're providing. In our slide, we give you an example that relates to student counseling services, but these are actions that the institution takes, at the resolution stage, and it's important that you consider, where the complainant or the victim is at that point. The second bullet point tells us that you may have a situation where you had offered an interim measure. Maybe it was a change in school schedule, maybe it was a change in living arrangements, changing professors, things like that, which had been declined at the interim stage. But you need to offer those again. You can't presume that the student will decline now. And I think there's good reason for this, which is that the effects of these kinds of episodes or incidents on victims, there's not a straight line or a continuum to it, based on a lot of research that's out there. So it's important that you're assessing what you can do for the victim throughout this process. And similarly, I think depending upon what you're dealing with on campus, you might have an environment that's similarly in flux. I mean, students can feel differently about events in proximity to when they occur and later on down the road. So it's important to consider, your goal is to try to alleviate a hostile environment if you determine one existed, and you can't rely on a snapshot from when the event occurred. You have to go based on what the current attitudes and feelings are on campus. Some examples of what remedies can be are provided in the department's Q&A, and they start on this slide here, 49, and continue on 50. I won't, in the interest of time, I'm just going to commend those to you, but it's obviously the intent is to try to as Tom said, reconstruct the learning environment, make it a safe place for learning to occur. And we've talked a little bit about, notice that, both parties need to be aware of this, so I'm pointing this out here, but just moving on to appeals. There isn't a requirement in Title IX that you have an appeal, although, as we say here on the slide, OCR recommends that institutions have some sort of appeal process where procedural error or previously unavailable relevant evidence could significantly impact the outcome of a case, or where a sanction is substantially disproportionate to the findings. It's hard to imagine any instance where that wouldn't be possible. So I think maybe, reading between the lines, OCR might be suggesting that they think appeals are a good thing. And I think from a due process perspective, I would agree with that. But there's, one caution, which is your appeals process cannot be unduly long. It cannot cause the investigation and hearing process to drag on. In the guidance, the department says, prior to the appeal, if you had one, they expect in the ordinary course that an investigation and hearing and moving on to remedies you could wrap that up in 60 days. They don't give you an additional recommended time frame for appeals, but I would think that that you probably have to be rather prompt in hearing the appeals. Again, they don't specify any particular procedures. I think your guide stars there are basically you need to embrace that concept of parity, and so impartiality and fairness are essentially the attributes that your appeal process needs to have. And if you think about the potential exposure that the institution has in litigation from a party to a process, I think the appeal is also helpful in the sense that it's that extra layer of due process that would be the defense that the institution would be able to raise should it be charged after the fact that its process wasn't fair to a particular party.
Okay, with respect to training, there are pretty comprehensive training requirements set forth in the Title IX guidance, and also with respect to the VAWA amendments for the particular instances of sexual violence that are covered by those amendments. The basic training responsibilities that institutions of higher education have to do with responsible employees, so they are aware of their obligations to report information about Title IX incidents to the Title IX coordinator. But you also have to educate your other employees who don't have formal reporting responsibilities so that they're aware at least of the institution's policies and procedures, so that if they do encounter a situation, they know what to do. There's a higher level of training obligations for those who are involved in grievance procedures. Obviously, they need to be aware of the standards with respect to the standard that the institution applies at the hearings, et cetera. So they have a higher level of training obligations, as well as the Title IX coordinator. The regulations and the guidance do not set forth a minimum number of hours that needs to be involved in this training, but we certainly encourage institutions to take every opportunity to provide training to institutions through a variety of means. There's more information coming out over time about what exactly the department expects in this area, but there should be an ongoing commitment to staying current with regard to developments in this area and to making sure that employees and students are aware of what the policies and procedures are and what they contain and their obligations under those policies. So that covers up through, that's really a summary up through slide 62.
I would just like to interject that a key here is we are an educational institution. The department expects us to be educating in this area, and it's important to educate absolutely everyone. That just cannot be overstated. It isn't just education for students or education for those people who are specifically involved in the grievance procedure. It's education on this issue for all of our faculty, staff, students, and everyone who comes into contact with students, that we can provide some basic input and training on this issue.
And with respect to retaliation, we've spoken a little bit about this already. So I think quickly, remember that there are really two obligations here. First, that the school as an institution can't retaliate against any complainant or anyone who brings a complaint on behalf of another student, and it also has a duty to protect victims, witnesses, and other participants in the process. Part of that involves making sure that those protected parties know how to report incidents of retaliation. It's not always, you're going to be charged with what you know or what you should have known. And so making sure that there are very clear channels and that those channels are understood by the affected parties is the key to making sure that you can effectively intervene and respond in cases where there's retaliation. Part of that explanation, needs to include not only that the institution's officials are going to take steps to prevent retaliation, but in terms of articulating, well, we won't be tolerated, and this is how you can report it. But the guidance here makes it clear that a strong responsive action and probably a very swift one needs to take place when it does occur. And again, as I said before, this is you're charged with not just what you actually know, but what you reasonably should have known. And I think that becomes another challenge here, particularly where there are so many different ways to harass or intimidate or coerce someone that don't require physical contact. And I'm thinking specifically of social media. It's hard for institutions to monitor this. So I think it's important that your procedures and your policy statements make it clear that you're defining retaliation as coercion, intimidation, and harassment. Whether it's occurring face to face, on social media, on email, or in any mode of communication. Finally, the department's guidance and the April Q&A makes it clear that their regulation in Title IX doesn't preempt or even expressly address First Amendment issues, because from their point of view, what they're doing is they're attempting to regulate unlawful physical sexual violence, which is not speech or expression that would otherwise be protected by the First Amendment. And I think that's pretty easy for most of us to understand, except that I do think there's a little bit of a threading of the needle with respect to stalking as a class of events that could lead to a Title IX case to follow up. Simply because as we showed earlier on, the definitions of stalking really probably can incorporate a lot of speech. And so I think helping you sort that out and thread that needle is that you can't go out there necessarily and try to regulate speech in the name of complying with Title IX. I think what you're focusing on is what's the intent here, what was the consequence. It simply isn't that offensive comments of a particular nature as perceived by some students in a vacuum, that can't necessarily rise to the level of sexual harassment or sexual violence for Title IX purposes. But I think it could if there's a specific intent by the perpetrator to injure an individual by saying those things, and if there's a threat communicated. But overall, there has to be that extra piece of it. It can't just be offensive speech.
Okay, the last topic we're covering on our slides, and very critical topic, is the recent amendments to the Violence Against Women's Act. The final rule just came out in October. The effective date is July 1st, 2015. And this was an amendment to the Clery Act. So the report, it included additional crime categories that need to be included in the statistics reported to the Department of Education. So in the fall of 2015 will be the first year that institutions are going to report crimes in these categories in their statistics for 2015 and 2014. But more relevant for purposes of the interplay between Title IX and Clery Act is that the annual security report now needs to contain some very specific information about victim rights with respect to notification of specific school policies and additional obligations of the institution to respond to these categories of sexual violence. So we've spelled out in detail what the ASR needs to contain I urge you to take a close look at it. There was a good faith obligation that institutions have complied with these requirements in their 2013 ASR, which was due by October 1st, 2014. So by October 1st, 2015, for the 2014 ASR, I think it's really important that schools have a really comfortable handle on what they need to be including in their policies and procedures as referenced in the VAWA amendments, and more so not just the technical language of what's required, but how the requirements mesh and interplay with your existing Title IX policies. So we have a good few months to continue to get institutions to have a comfort level with what's required under the VAWA amendments, but these next few slides really talk about in detail what needs to be in there. And again, institutions need to be taking a look at how these policies interplay with Title IX. I know the Department of Education said the VAWA amendments made no changes to Title IX, but in my view, and I think the view of others, they really did add to the specific requirements articulated by the department with respect to what needs to be in policies that are arguably Title IX policies. So there is a definite link there, and urge you to get familiar with it, and we're available for specific questions after this call about exactly what these new requirements mean for institutions. So I think, do you want to just go ahead and open it up for questions? Because I think we've covered all the substantive slides at this point. Jenny, do you want to open it up for questions? Okay. Well, Tom and Steve, do you want to make some wrap-up comments about what we've had to say today?
I will take just one. We are all institutions of higher education. Education is our byword. We need to educate around this issue. And the education needs to go to students, staff, faculty, all of our folks. This is an important area that we have an opportunity in a very interesting way to have profound impact and try to lessen the number of these issues. Our real intention here is not to be the best grievance process handlers. It's not to have the best of all possible investigatory systems. It's really to try to lessen the number of changing behaviors and helping
the question is, can the Title IX coordinator be designated at the corporate level? And I know there's a number of proprietary institutions on the line that have things consolidated at the corporate level for particular branch operations. So that's a good question there.
Well, the real issue is how accessible is that Title IX coordinator to the individual students who might want to take advantage of that person or might need to take advantage of that person. If at the corporate level that person is accessible to the students on the campus or otherwise, I don't see any reason that it can't be at that level. But I think the risk that you run is that the coordinator would be viewed as not appropriately accessible. So you would have a little added burden of demonstrating accessibility here.
Yeah, I think one thing I could add is that you do have to have a Title IX coordinator, and that individual can have can delegate some discrete duties, but needs to be identified as the Title IX coordinator. And so, if you wanted to have a corporate Title IX coordinator, I think that person needs to have very frequent contact on campus, and if there are deputy, Title IX coordinators, at each one of your locations where complaints can be taken, perhaps that's doable. But you've got to make sure that the students know how to get in touch and can, as Tom said, get in touch with the Title IX coordinator, and I think everyone has to have equal and sufficient levels of training.
Okay, the next question we have is with regarding who should be on the investigative team under the direction of the Title IX coordinator, and the department hasn't provided guidance as to who they think specifically should be on the investigative team or the grievance panel, et cetera. What they have said, though, is to avoid having students play a role on those grievance panels because they feel that they don't have adequate maturity and may have conflicts at the peer level that would potentially influence their judgment, but they haven't said that you can't have students. So they have not said who you should or should not have. They just should not have a conflict of interest and be well trained.
Yeah, I think this is one of those questions where you need to go back to the OCR's guidance that says take into consideration the age and experience of your students, your resources and your own experiences in the past. I think, on some level, you need to have student-wide or campus-wide buy-in to the process, particularly if you're going to, accomplish anything with the prevention and remedial aspects of your Title IX compliance program. And it may be difficult on some level to achieve that if you don't have some student participation in the investigation process. I mean, you need to. What I'm thinking is that you need to have that process be seen as legitimate to the students, not just for the deterrent effect, but also because and more importantly, students who are experiencing or who are victimized by sexual violence need to know that there is a system that works, that they can rely on, and that they can avail themselves of. And I think
that's really a good point.
Yeah.
The persons involved in this have to have enough gravitas, have to have enough authority that both victim and the perpetrator will find that they have been credible in the judgments that they make and the remedies that are developed, regardless of what those judgments are and remedies are. So the people involved have to have some basic credibility to them. They have to have the right demeanor, so to speak, or you will not be accomplishing all the objectives that you have here.
Okay, the next question we have is, it says we are a small commuter school with 200 students and a small staff. 90 are online, and there are 98% females in the entire program. Do we need to have a policy? So we need to have a policy in our catalog, but do we need to have a Title IX coordinator? And I think the answer is absolutely. You need to. It's the law. And it's not just the residential schools that the department is going after. If there are complaints, for instance, even if you have online students or online faculty, there could be cyber stalking issues. But the department has entered into a resolution agreement, for example, with one of the Paul Mitchell Barber School in California, and in the department's comments, they've indicated that institutions of all shapes and sizes are subject to Title IX, and there's no school too small or structured so they don't have to have a Title IX coordinator. So I think that answer is clear. Okay, the next question is, in the context of an employee victim and an employee respondent alleging only sexual harassment, does the institution have to follow the investigative procedures outlined by the Title IX guidance?
Well, what you'll have is grievance procedures that you'll define as applying to sexual harassment. So if there isn't a incidence of sexual misconduct or sexual violence, if it is, as you're describing, sexual harassment, you still have the same duty to investigate and respond. What's different is there are you'll have probably a few more possibilities open to you. For instance, the OCR has said that you cannot mediate or informally handle through mediation a complaint of sexual violence. And the common sense reason for that is because you're probably dealing with two people who shouldn't be in the same room together due to the effect that that's likely going to have on the victim. But if in the absence of anything that would be defined as sexual violence, maybe you can mediate it. But the point is that you do have to handle it in accordance with your published grievance procedures. Those procedures do need to address what you do in instances of sexual harassment, because sexual harassment is sex-based discrimination for the purposes of Title IX.
Okay, the next question is, in a multi-campus institute of higher education, does each location need a Title IX coordinator?
We kind of touched on that before. I think the best practice, the answer to that is absolutely yes. The real question is accessibility of that person. So you could have a coordinator for all of your multiple campuses, but deputy coordinators on each. I think that would probably work. But the real focus is that person known to the students? Can the student easily present the issue, the complaint, to the Title IX coordinator? And if the answer to that is distance makes that difficult, then you better not do it.
Okay, the next question is, could it be considered legal advice when advising the victim of their right to take criminal action against the perpetrator? And I think with respect to the changes to VAWA, you're actually required to tell the student that they can file a criminal action. So it is, in my opinion, that is not by any stretch of the imagination legal advice, and that in fact the department is leaning toward, with respect to the new categories of sexual violence, making sure that the institution is advising them of their right to take criminal legal action.
Yeah, I agree, Catherine. I don't think, if all you're doing is providing that notice, you can't be compelled into creating a legal relationship, by operation of this law. But I guess, just to be on the safe side, we should also say that, it probably does depend a little bit on what you're telling them. If you're advising them on strategic things, or recommending a certain course of action other than, you have the right to, swear out a criminal complaint. And I don't think it would be hard for institutions, to stay on the right side of that line. But particularly if you are a responsible employee who also happens to wear a legal hat, I do think that it will ultimately depend a little bit on what you say to that student.
Okay, our last question here is a good one. How do we investigate a possible stalking or harassment charge that was posted on Facebook when we have limited options discussing it with a student based on freedom of speech?
Well, a couple of things. The best way to, put yourself in a position to investigate an incident like that is, number one, to make sure that, the students understand that, what constitutes harassment or what constitutes stalking, which would include this kind of behavior online, and that they should report it to you. That's the best way for you to, make sure that you actually get knowledge of the complaint rather than have something occur which you should have known. And with that in mind, I don't think that the standard here that applies to institutions is that you have to have rights to monitor everyone's activity in social networks. That's just not reasonable. But where you'd be criticized would be if this is happening, if a student is affected and didn't know that they could turn to the institution to make it stop. But I think there's also a part of the question, the part that says we have limited options discussing it with a student based on freedom of speech. If what that is implying is that the student's not cooperating, I did want to mention one thing, which is, oftentimes the complainants may not, for a variety of reasons, really participate in the investigation, and that doesn't relieve the institution of the duty to conduct a full, fair, prompt investigation that's adequate. So you have to do the best with the information you have, and offer interim measures and remedies to try to possibly put the victim in a position where cooperation is easier for them.
Okay, well, we got through the questions. Unless there are any final remarks, I'm not sure if Jenny is able to, if her mic is working or not. But I think we've wrapped it up. Oh, there you are.
I'm back. I don't have any additional questions, so if anyone wants to have any final words, we can go ahead and do that, or we can just go ahead and wrap it up.
Well, I just wanted to say thank you to everybody for the opportunity, and I know we ran significantly over time, so thank you for hanging in with us.
And again, I'll have a PDF of the presentation available at the Career Education Review website along with the recorded webinar. And I'll send an email out with the link to that information either tomorrow or Monday. And I also want to thank Peter, Steve, and Tom for joining us today and for taking the time to discuss on this important topic. So thank you, everyone, and have a great day.